Actually, we do have one other.
Yes, I've seen.
It's up to you.
Resident.
Shall we,
Yes, yes, please admit him. Good morning, Mr. Dyson.
Good morning.
Good morning. I'd like, please, if you could keep your if you can stay on mute. Only if you need to ask a questions, then you will unmute it, please.
Sure, thank you.
Thank you.
And we're good to go. We're live.
Yes, please, Sean.
So, Jay, you're good now.
Thank you, Sean. Welcome to today's hearing. My name is Councillor Baclini and I shall be chairing the meeting. My colleagues, Councillor Martin, Councillor Nakpal and I comprise today's subcommittee. Alison Luff is the legal advisor to the subcommittee and Sean O'Brien is the Democratic Services Officer who is the clerk to the subcommittee and who will be minuting the meeting. You will have all received or seen the agenda pack within which is contained the licensing officer's report with details of the application in section 1. To confirm, we are dealing with a new premises license application in relation to Angels Club, basement 25 Broadway, West Ealing, W13 9DA. We note the following representations objecting to the application have been received. One representation has been received from the Metropolitan Police Service. One representation has been received from the Licensing Compliance and Enforcement Team. One representation has been received from the Pollution Control Team, and 7 objections has been received from members of the public. The subcommittee have read all objector submission in the agenda and will take them into consideration when making their decision. In accordance with procedure, I shall invite the applicant to present the application, answer any questions and call any witnesses. I'll invite those who have made representations to make their representations, answer any questions and call any witnesses. At the conclusion of the hearing, the subcommittee, accompanied by the legal advisor and the committee Democratic Services Officer, will retire to consider its decision. The decision will be given at the end of the meeting and confirmed in writing forthwith. If the panel cannot reach a decision today, you will be notified in writing within 5 working days of the panel's decision. I will start now by asking all present and intending to speak to introduce themselves, please, starting with the legal representative, please.
Everybody, I'm Nick from the licensing guys and I'm representing Bianca, who's online today.
Thank you. Bianca?
Good morning, everyone. My name is Bianca and I'm the applicant.
Thank you. Sergeant?
Good morning, Chair. Good morning, panel. Good morning, everybody. It's Sergeant Dimitri Kassar from the Metropolitan Police, and I am in at Ealing Council with my colleague.
PC Vicky Hewison, Licensing Police Officer. Morning, Chair.
Morning. Mr. Dear?
Thank you, Chair. Bob Dear, Licensing Compliance and Enforcement Officer, Ealing Council.
Thank you. And Mimi Stupa, please.
Good morning, everyone. Mimi Stupa from the Noise and Nuisance team.
Miss Anne Chapman?
Good morning. I'm Anne Chapman and I chair Walpole Residents Association.
Thank you. Mr. Dyson?
Morning all, Rob Dyson. I'm a local resident.
Thank you. Have I missed anyone? I don't think so. In this case, let's proceed, and I will be inviting, please, the presenting premises representative to start his presentation, please.
Good morning, everyone. I am Nick Semper from the licensing guys, and we are representing the applicant here today, being Bianca Alenkai, for a members club that she wishes to open in the basement of number 25 Broadway called Angels. The objects of the club are for the provision of facilities and amenities of a private club or on commercial premises for the purposes of facilitating the social interaction, entertainment and relaxation of persons connected with or interested in Asian arts, music, culture, business opportunities, etc. We would also like to provide Bollywood and belly dancing as a form of entertainment to persons who've already subscribed as members and their guests. Events are publicised through the members' email lists and attendance is booked thus. Once booking capacity is reached, then that is that. No further admissions. Now, this application is in fact a re-application following a previous application heard by the Licensing Subcommittee in May of 2024. At that previous hearing, the applicant was unrepresented. It was suggested by representatives of the responsible authorities that performers at this establishment would be highly likely to be susceptible to sexual harassment, indecent and sexual touching, and inducements to perform sexual favours for money. Concerns were raised about safeguarding, violence against women and girls, and private dancing. Indeed, one officer of Ealing Council described the applicant's application as just a front to allow illegal activities in a small basement club. I'm at a complete loss to understand upon what grounds or evidence that particularly serious allegation was based. Other objections raised concern poor sound insulation and SIA staffing provision. Now, the applicant has reflected upon the content of the hearing and has resolved to reapply, and in doing so has addressed the issues raised in the following manner. Firstly, Bollywood dancing and belly dancing are neither sexual nor adult forms of entertainment. All forms of sexual and adult entertainment are now addressed in bespoke conditions contained in section 18 within the operating schedule before you. Reassurance around safeguarding is now being prioritised. The applicant has undergone WAVE training and is now a champion of the Women's Nighttime Safety Charter. Policies have been prepared to embed safeguarding within the operating schedule, and further conditions have been added to reinforce safe working principles. A noise report has been commissioned from a qualified sound engineer, and their analysis of the building confirms that the walls will provide significant noise reduction and the breakout into the passageway will not affect residents due to no windows and other doors in the passageway. Now, as you'll be aware, I'm sorry, it's a bit of a preamble, I'm sure you've heard this from me before and others. As you'll be aware, each application must be judged on its own facts and merits. The significant merits of this current application is that a quality application correctly conditioned with specific, appropriate, proportionate control measures, thus minimising any potential that any licensing objective would be undermined. In this hearing, the burden is on the applicant, i.e. me and Bianca, to show that the proposed operating schedule, supported by the proposed operating the operation supported by the proposed operating schedule is capable of promoting the licensing objectives and is unlikely to undermine them. Any representatives opposing the application have the burden to show that these premises trading under this operating schedule will undermine the licensing objectives and demonstrate that with evidence. In our submission, any subcommittee properly advised could only refuse this application if it is found on the evidence of the representatives to be not capable of promoting the licensing objectives. So you may ask yourself, why do the representatives, aka the objectors, need to produce evidence? That answer is found in para 9.43 of the section 182 guidance, which clearly states, and I quote, the authority's determination should be evidence-based, justified as being appropriate for the promotion of licensing objectives and proportionate to what it is intended to achieve. Now, there appears to be 3 objections from the responsible authorities and several from neighbours. However, the matters raised appear to have been addressed by us following the last hearing. Now, so I'm going to deal with each in turn if you'll allow me. Sergeant Kassar from MAPPOL explains that our customers will be allowed to start drinking at 12 o'clock lunchtime and get themselves into such a state of inebriation that when the performers start to dance at 2300 hours, they will be unable to keep themselves to themselves in the face of such erotic dancing, thus posing risk of sexual offences being committed. I've got some things to say about that. Firstly, the performance of dance was deregulated by the legislative reform, open brackets entertainment licensing, close brackets order of 2014, and that such entertainment only becomes a licensable activity on licensed premises to audiences of less than 500 people after 11 o'clock at night. Therefore, the performances of dance can start at 12 o'clock lunchtime, and there is no need for customers to drink in this establishment for up to 11 hours before any performance commences. Secondly, and very importantly, Bollywood and belly dancing are not erotic forms of dancing per se. I provided a list of websites offering Bollywood dancing in Ealing, whether in the form of hired performance or performers, or dance classes, even for children. Moreover, for the purposes of the Licensing Act and therefore this committee, the correct consideration to apply is whether Bollywood and belly dancing is a form of sexual entertainment. It is not. Sensual it may be, but sexual it is not. Now, I've thought long and hard about this, and with the exception of Morris dancing and break dancing, I cannot think of any form of dancing that is not sensual to some degree or another. Indeed, dancing around the maypole was originally a fertility ritual, and even the waltz, when it first became fashionable in the early 1800s, was perceived by some to be highly immoral. Now, we as a society have moved on. Thirdly, Bollywood dancing is an art form. We're in danger of allowing unconscious bias to create an implicit stereotype that these dancers will be providing sexualized erotic entertainment in such a way as to invite unwanted, unwarranted, and unreciprocated sexual advances from the customers, or that this applicant and these performers might welcome it, or be obliged to provide sexual favours for money. Furthermore, there's the implication that the applicant will aid, abet, procure, encourage, cause or permit such behaviours at her club. There is zero evidence of that. And frankly, she finds even the mere insinuation of it offensive. In summary, these stereotypical suppositions concerning the applicant and the third-party performers are unsupported by any evidence and are both highly offensive, unconsciously biased, culturally insensitive and institutionally racist, as it casts doubts on the nature and propriety of the entertainment as an art form, stereotyping the entertainers as sex workers, the applicant as an enabler of just a front for illegal activities, and the customers as lechers and or predatory sex offenders. Mr. Deere for the Licensing Authority echoes concerns regarding morality and safeguarding. So let's just explore that for a minute anyway. We provided the evidence of Taya Mihescu, Emanuela Boldea and Hafiz Junaid to say that those kind of activities don't go on at these premises. Bianca has become a champion of the Women's Nighttime Safety Charter, has completed WAVE training and has produced a raft of policies and procedures to design out such behaviours. The staff have been trained in safeguarding and the club has numerous posters on the wall setting out expectations and explaining procedures to staff and customers alike. Additionally, the objectors are overlooking a significant fact that these premises are bristling with technology in the form of a CCTV system that records everything that occurs therein. In the event of any suggestion of lewd or indeed unwarranted, unreciprocated or unwelcome sexualised behaviours, then a digital record of what then and there took place is available to police immediately and on demand. The mere suggestion of such conduct could be investigated thoroughly and within the day. The presence of such a comprehensive CCTV system provided by Bianca herself must surely reassure everyone that she has no intention to tolerate, let alone encourage, such antics in her premises. There is some suggestion that there is insufficient SIA present for what is proposed. The standard ratio of SIA to customers is 1 to 75. Here we have 1 to 35. Additionally, we've provided evidence that the clientele attracted to this kind of establishment are not high risk, and there is no evidence from the responsible authorities before you to the contrary. Now, Ms. Stupu from the Noise and Nuisance team and Mr. Deere from the licensing team also believe that noise nuisance will emanate from the premises. We have, however, provided expert evidence that it will not. So please, I point you to the sound engineer's report in the bundle. The author is Paul Schmetz, an MBA and chartered mechanical engineer who specialises in vibration and noise. He's a Bachelor in Education, holds a Master's in Philosophy and a PhD in Vibration, Structural Dynamics and Sound Radiation, and is a member of the Institute of Acoustics. He works as a consultant for other councils around the country and also undertakes private client work, of which this is an example. I am not an expert myself, but will let his report stand against the speculation of others that these premises will cause a noise nuisance, and respectfully ask that you award appropriate weight to his expert opinion. The responsible authorities worry about footfall and associated disturbances. There will be no large queues outside, as the capacity is limited to 35 and attendance is pre-booked. If you're not a member or their guest and have not booked in, you can't come in. Simple as. These premises therefore cannot become the venue of last resort in the Ealing nighttime economy. I would also observe these premises operated as planned under the authority of temporary event notices between April and May, or May of this year. Yet the council received no noise complaints whatsoever. Not that I think that was in the evidence of the last hearing. The absence of evidence of noise nuisance is, in fact, evidence in its own right that these premises, when operating, do not constitute a noise nuisance. If it did, then there would have been numerous noise complaints recorded during the aforementioned period, and these would be before you now as evidence of noise nuisance. Incidentally, Ms Thupu also raises other matters contained within council officers' reports, which are best dealt with, I would suggest, in private session if the committee wish to do so. If you wish to explore those sensitive issues, then I suggest we do go into camera. Whatever those allegations may or may not be, they did not occur on licensed premises or within the influence or control of this applicant. Para 2.27 of section 1.8 guidance gives us direction on this, where it says, beyond the immediate area surrounding the premises, these are matters for the personal responsibility of individuals under the law. An individual who engages in ASB, etc., crime or what have you, but ASB, is accountable in their own right, end of quote. Therefore, whatever did, or if we go there in private, did not happen of a sexual nature in an alleyway outside, has no bearing on the conduct of the applicant or these premises. Now, we got some representations from neighbours who feared that there would be problems with this licence to be granted. However, we countered that with a noise expert's evidence, which I eventually suggest is extremely persuasive, and the first-hand evidence of Mr. Kerrigan, who I'm afraid can't get time off work today. He's provided a representation in favour of this application. Now, his home is accessed via this alleyway, and he explains to us that that alleyway was frequented by itinerants who slept in his bin store and conducted their nefarious activities down there out of public sight. And he's telling us that as a result of that club opening, those antics have been displaced. He actually welcomes the presence of a new club, their customers, and the in-house SIA element. Now, again, it's pretty standard stuff, but I'm going to have to just whiz you through it. Let me now talk to you about fear and speculation. All the representatives against this application speculate that were you to grant this licence today, then they fear that there may be problems. There are two main reasons why fear and speculation are not admissible in these proceedings. Firstly, para 9.43, the section 182 guidance clearly states, and I've told you before, that your decision should be evidence-based. Fear and speculation of what may or may not happen at some undisclosed point in the future or as a consequence of any decision here today is clearly not evidence. It is what it is. It is fear and speculation. And secondly, there was the ruling in the stated case of Daniel Thwaites and Wirral Magistrates Court back in the High Court of Justice in 2008, whereby Her Honour Justice Black handed down a judgment which indicates that your decision should be actuated by, inverted commas, proper and inverted commas, real evidence. There is no history or evidence of problems at these premises, no evidence before you to the detriment of Ms Allen Kai which links her to any unlawful activities, and the potential for or prospect or likelihood of any such problems occurring is more than properly addressed in section 18 of the application before you. In any event, Parliament has already provided a mechanism to deal with any future problems emanating from licensable premises at these, or licensable activities, I should say, at these, or indeed any other premises in Ealing. That, of course, is the premises licence review under section 51, of the Licensing Act 2003, which you as an authority are more than familiar with and are never reluctant to invoke. So were you to grant this licence and problems were to ensue, our position is they won't, but we can no more look into the future than anybody else on this TV screen, then the statutory mechanism to control those problems going forward is self-evidently provided through the aforementioned section 51 procedure. Okay, so I'll rest now with your permission. I'll deal with any further questions or queries in summary, if you'll allow me. But in conclusion, I'd ask you to look favourably on this well-conditioned application for this de minimis operation. Thank you very much indeed. Thank you.
Thank you, Mr. Semper. I'll move now to questions to Mr. Semper and Ms. Alenkei. Just wanting to see if Sergeant has any questions.
Morning, Chair. Morning, Nick. Nice to meet you.
Hi, Dimitri.
Hi there. Thank you for a very detailed and thorough detailed argument. I just wanted to ask you, Ms. Alenkei, in the previous application, stated that this venue would be primarily for South Asian males. Now, I know you've used the whole thing of institutional race, or not institutional, but, you know, about prejudices and stuff like that.
Unconscious bias, I think.
Yeah, the unconscious bias. Yeah. What I'm asking is this still going to be the case in point with regards to demographic attending this?
That's a really good question. Thank you very much indeed for that. Okay. No, and you rightly pointed out the last hearing. And by the way, what happened? This is a new hearing de novo, and anything that happened in the previous hearing isn't evidence and whatever. Yeah. Poor Miss Alenkei got herself into well, you know, it's not pleasant viewing when you watch it. And got tied up in knots. Yes, clearly Bollywood dancing and belly dancing appeals to aficionados of that kind of art form. However, this one building can have 1,000 users, and I mean, yeah, it is just to read you the sort of just to read you the objects of the club again. It's for the provision of facilities and amenities of a private club run for commercial premises, principles for the purposes of facilitating social interaction, entertainment and relaxation of persons connected with or interested in arts, music, business opportunities and culture. Okay, that's a very broad net. I'm sure that the young lady wouldn't want to tie herself down to one particular demographic. I'm going to try that once more. Easy for me to say. Demographic, I got it. But when not in use as licensed premises, these premises can be hired or used for other purposes such as yoga and fitness classes, group meetings. For example, the local autism awareness group wish to use the place. So, you know, it's just because it's licensed, it doesn't mean it has to be used for licensed activities at the time specified. We like the facility. We don't intend to be open these full hours and providing this form of regulated entertainment these full hours. It's just we'd like the facility to do so, if at all possible, please, Sergeant.
Okay, thank you, Nick. The other thing I wanted to just ask you, and thank you for laying the fears with regards to the violence against women and girls, the VAUG elements, as MOPAC. It's a strong directive and under the Mayor of London. In terms of the dancers, if I may ask, just from a safeguarding perspective, how will they be recruited? Following on to that.
Well, hang on, let's deal it with one thing at a time. Okay. Recruitment of dancing is not a licensable activity, but if you're asking about how they'll be booked, that's covered in section 18 of the application, and it says that, where is it? Must be employed via a bona fide events and entertainment agency, examples of which are provided in the supplementary information before you, boss.
Additional documents have been received, Sergeant. Yes. And
I did see those
contains
this morning.
Websites where you can
get into them, could we? Okay, fine. Okay, yeah, no, fair enough. Thank you. In terms of the operating within the venue, as we know, Nick and Bianca, the premise within, you know, the actual foot space within the venue, it is quite small. So in terms of the structure, having gone down there, I'm aware that there are the chairs on the side, and then the dance will happen in the middle. Is that correct?
We've addressed that also in the operating schedule. I think if you can anticipate me taking you to where I think you're going, we've put in that 3-foot rule that Bob mentioned at the last hearing.
Yeah. How will that be enforced, if I may ask, Nick?
Well, we've got the staff, we've got Bianca down there, we've got the staff down there, and we've got a roving SIA guy. But this is all assuming that people will not be able to control themselves and will not keep their hands to themselves. That is a massive leap. We've got no evidence of that.
No, we haven't. You're right, but you must understand from a policing perspective, Nick. I do have to be aware of the safety of the people that are employed there, and if they are women, and as you've alluded to earlier, whilst Bollywood and belly dancing is not of a sexual nature, it is still erotic, is it not?
I'm not sure it is. I mean, if it was that erotic, the British Board of Film Censors, whatever they're called nowadays, would be dialing up the PEGI, the rating on Bollywood films. But you know, belly dancing originated for dancing between women. Now, some people find it erotic, but I mean, there's all sorts of fetishisms out there, from anything from amputees to smoking. I mean, it doesn't do anything for me. But you know, what people find erotic is within their own minds. Now, you're asking how these women are going to be safeguarded. We've got a raft of conditions down here in Section 18. We've got a raft of training, and the staff are aware of this, and the whole place is bristling with CCTV, sir.
Yeah, no, fair enough. Now, I've read one of the statements, well, I've read all the statements of the truth statements that you've submitted. So with regards to the dancer, I think her name is Miss Baldia, forgive my pronunciation. Now, they've alluded to the use of tokens in terms of a performance. Can you elaborate a bit more for me how that is going to work? So my understanding is the viewer, which say would be you or I, we're sitting at the table, you put a token down. How does that actually work?
I am not an expert in Bollywood dancing. She's tried to. Sorry, Chair. Yeah, it's your turn. Go ahead.
Mr. Semper, I think the best person to answer this question would be Miss Bianca Alenkai, if she could explain to us, please.
Surely.
Yes, hi, good morning all. So basically the members and their guests can purchase the vouchers from the bar, and they will buy these vouchers, and they will use as tokens of appreciations towards the performers. And they will put down on the table, I don't know, maybe 5-10 tokens, whatever they want, and after the performance, the dancer will be able to, well, not the dancer, but someone else, like myself or someone that I will hire, will collect the vouchers and give it to the performer. She will have her own box to collect her vouchers, and yeah.
Yeah, Dimitri. This is apparently, I mean, I'm not a you know, an aficionado of this thing, but this model of tipping the dancers for a good performance is standard, I understand, amongst Bollywood performances. If you go on, look, I haven't put it in evidence because I didn't think it would be I didn't think it would be contested, but if you go on YouTube, you can watch the ladies dancing and the gentlemen dancing, and young children will come up to the stage and they will shower these vouchers onto the performance area, and these are collected afterwards.
Okay, but Mr. Semper, in your application, I know you've got the challenge 25, so we're not alluding to young girls doing dancing at this venue, are we? We're alluding to adult women doing the dancing at this venue. And I'm sorry to say, sir, but to challenge you with regards to that, and Bianca, is that whilst these are adult females, and whilst you might say that I am being unconscious bias in my perception of Bollywood dancing or belly dancing, I'm really sorry. I have been to Istanbul. I have seen belly dancing. I've been to a venue where
so
people. No, hang on. Let me just finish. Let me just hear my say. And they are of an erotic nature. Okay. Now, the point I'm trying to make is, and this is to you, Bianca. So they get these tokens. Does this token then fall within the form of remuneration towards your dancers?
You're on mute, Bianca.
Sorry. Can you repeat the question, please, if you don't mind?
I said, in terms of the tokens, does this fall into remuneration for your dancers? Is this how they then get paid?
Yes.
Yeah.
So that's it. So in terms of the financial aspect, because as mentioned before, what my concern is I don't want these girls to be forced, and granted, I don't have the evidence, Mr. Semper, but what I am concerned about is just this, from a safeguarding perspective, these women being put into a compromised position. And I don't mean by being touched up or anything like that, but potentially putting them in a position of difficulty. Now, my question to you, Bianca, is how do you then control, and how exactly do these tokens work in terms of remuneration? How is the appreciation shown in terms of the dance that specific dancer then performs to the client present?
So basically, at the end of the night, each dancer will count their vouchers. A voucher is worth £5, and then at the next day, the company that sent me the dancers will invoice me, and I'll have to pay the company, basically.
So you then pay the company, and then the company then will pay the dancer. So exactly. that company then works as the agent for the dancer. Is that correct? Is that what you're stating?
Yes.
Okay. All right. So coming back to you then, you don't pay them per se from the venue itself, as in you don't pay them. It goes via you, so you're like a third party that then gives it to the agent and then pays them accordingly.
Yes.
This is Matt, Dimitri. This is covered in the statement of Teo Mihescu.
I know. I just needed clarification, because it was a bit complicated in terms of drawing the line of how the person performing the act, so the employee, gets remunerated. And what concerns me is that I don't want them to then be put into a difficult position. That is all I'm saying, Nick. And again, I will preface, it's not evidence-based, but it is just a concern I have regarding this. Okay, and I'm not being accusatory at all here. I'm just asking to understand the machinations of how it operates.
Okay, the operation is explained in page 2 of Teo Mihescu's statement. Okay, and to counter this your concerns, right? I pointed out that everybody's been trained, expectations have been set, expectations are posted up on the wall. The place is heavily surveilled with CCTV. These behaviours will not be tolerated. They're unwelcome, unwarranted, and unreciprocated. Thank you, Dimitri. Thank you.
Thank you. Chair, at this stage, I don't have any other questions. Thank you.
Thank you, Sergeant.
Thank you for your time, Chair and Council, and Nick and Bianca.
I'll move now to Robert Deere and see if you have any questions, Mr. Deere.
Just a couple, Chair, very quickly.
Go ahead.
I don't mind who answers, either Bianca or Mr. Semper. On the application, it mentions a private changing space shall be provided to performers to allow them to dress prior to any performance, should they require it.
We can't hear you. Mr. D, we can't hear you.
I think he's frozen, Chair.
Yes.
I'll have a go. I'll have. Is he there?
Nick, I think I understand, Chair. So I did have this as a question.
Yes.
I am aware that they were talking about a changing facility for the dancers, or lack thereof, I don't know. But in terms of the dancers, where would the facility be for them to change? In other words, when you have a performance type environment, there should be a designated change room for the performer. And forgive me, I do come from that background, Nick. I do understand the whole thing of theatre and all this kind of stuff in terms of performance. There should be a safe place, especially for women. And Bianca, I have been, so I'd like Bianca to answer this if that's all right. I have been to your venue. It is quite small. Where is a safe changing place for the dancer, the performers, or do they come dressed already?
You're on mute,
You're on mute.
Bianca.
Sorry. They don't come dressed already. They will change into the ladies' room, which will be surveilled by the SIA, either or me, or yeah.
Is there a door then? Is it like a fixed room, or a small dressing room for them?
It's a ladies' toilet.
Okay.
It's not a dressing room.
All right. Okay. Thank you.
Thank
Hello?
you, Sergeant. Yes,
Chair, can you hear me
yes,
now?
Mr. Dick. Yes, I can hear
Turned
you.
off my camera, maybe that might solve it.
I don't know if you've heard Bianca's answer
have.
to your. Okay.
Yes, I
Okay.
have indeed.
We still have some questions.
I have just about 3 or 4.
Okay,
Are those
go ahead.
toilets, i.e. male and female? Is there a male and female toilet in there? Because it looks very small on the map, on the plan, sorry.
So it's a toilet. And so basically, we have a door which leads us into a small area, and then another door which leads to the toilet.
Right. So basically, it's just one toilet for the customers, staff, and the dancers.
Yes.
Right. Okay. On your, or so I don't mind who answers, on the previous application and this application, you mentioned the capacity will be 35. In the last one, that included staff as well. Which one is it? Is it 35 customers or 35 customers plus staff altogether?
35.
My understanding. All right, Bianca, you go. I think that's 35 plus staff and SIA.
So do we know what the capacity of the premises is with staff, and is it 40?
So we have 35, including the staff.
Right.
Here.
So
how many members of your staff, Bianca? Yeah. That's the question. How many members of your staff work at the club?
Well, there is going to be 2 bar staff, myself, and the SIA.
So 2 bar staff and one SIA, or you said 2?
Depending on the night, I might hire 2 or 1. As far as I know, we should have 1 SIA for 75 people, but we're only going to have 35 people, including staff.
So you have 2 bar staff, 1 SIA, and yourself. You'll be present all the time, because I think you're the DPS, aren't you? Okay. Mr. D, you've got the answer. So it's around 40 people.
Well, I think Bianca just said, Chair, sorry, my apologies. I think Bianca said it was 30 or 31 plus the 4 staff, so 35 in total.
Oh,
that's correct, Mr. D.
Okay.
Thank you. Thank you. Sorry, Bianca, very quickly on the tokens. Hopefully you'll be able to answer it very quickly. Do you charge the customers a percentage for buying tokens?
No.
No. Does the entertainment company who employs them or pays them, do they take a cut of that £5, i.e. 10%, 20%?
I suppose they do, otherwise they wouldn't hire them. I think.
Yeah, I
No,
don't
no,
think,
it's
Bob, I don't think she can answer questions for
No?
Teo Mikescu.
Okay, that's not a problem. And on the doorman, maybe one for you, Mr. Semper. You mentioned that the standards say 1 per 75, obviously, but that is roughly, i.e., taken into consideration. This premise is a basement. It has a door where and in the security industry, the easiest place to stop trouble is at the door. I think everyone in this meeting will agree with that. So he stays at the door. What happens downstairs? Because is Bianca SIA trained or any other staff trained?
Well, Bob, you know that as a club manager, you can't double tap as an SIA officer. That's as well as doing other duties. That's not permitted. Also, if you go to hang on, no, Bianca, thank you. Secondly, as concerns SIA, it's on a risk assessed basis. So, for example, if you're anticipating more risk, then you'd up the SIA. I'm not sure you need 2 SIA when the standard ratio is 1 to 75. She's got 1 to 35 at the moment. When doing regulated entertainment, I'm not sure that you actually would need more than that. And certainly on a risk assessed basis, if you only got 5 customers down there, putting it in that you need 2 SIA at all times, that would be completely disproportionate in defiance of the guidance. So I think that the SIA quotient is covered in the condition within section 18 of the application, Bob.
Downstairs. And if
I think Bob, we're missing you, mate. We missed the first bit of that.
We didn't hear what you said.
Okay, sorry, I'll make sure again. It's funny, Nick, I'm looking at the screen and you're on mute and you're coming across every time.
I'm not on mute. I'm not on mute, Bob.
There's a lag. It says you're on.
Yeah, there's a lag on your system. Okay, right now look, I've already told you. No, hang on. When you got 35 in, right? Yeah. That's it.
Yep.
Okay. You don't need to stand or 31. Okay, but 35 persons on. Okay. Yeah. You don't need to stand at the door because everybody's coming and in. Yeah. Okay. Yeah. You know, and it is such a tiny place. You can do security on a place that small, 1 to 35. Okay, when it's such a discreet crowd. The fact of the matter is, we know everybody that's in there because they're already members, they're already signed in. We've got their names, we've got their addresses. The place is covered in CCTV. This is in my submission a low risk, low intensity, low hazard venue. Okay, from an SIA point of view. But that's my submission on that. Thank you.
All right. And obviously the doorman says that he's how long's he been a doorman? Do we know, Bianca? Sorry, my apologies. Because it sounds like he's risk assessed it.
You're on mute, Bianca. Okay.
Sorry, I didn't catch that. Can you repeat?
Mr. D, can you repeat the question for Ms. Bianca?
I'm sorry, Chair. The doorman that has made a statement of truth has stated basically that only 1 doorman is required. I'm just wondering how long he's been a doorman, because it appears he works for a company, I take it.
Yes, he does work.
Can I come in on that? Yes. His current badge was issued in November 2023. That's in the statement of truth. I haven't got the history on what his career has been within the SIA, and we can't answer that because we'd be guessing. And as opposed to the last hearing, I'm trying to keep this as evidence-based as possible. Yes, he does work for an SIA company. The SIA company have been out as part of onboarding a premises, and they have set their staffing level in accordance with the risk and in accordance with the instruction, for want of a better word, as 1 person can manage that.
Okay. One last question, Chair. Sorry. Going back to the plan, which obviously I appreciate is very small. I didn't enlarge it. I should have. The store at the south of the map, should we call it? It doesn't appear to have any CCTV. I was wondering what that store's used for. You're on mute,
Hey.
Bianca, again.
Lee, can you tell them what's in that store?
It's just for storage for juices, you know, things that we use. Alcohol storage, we don't keep anything in there. It's just in storage.
Right. Okay. No problems. Thank you very much. Thanks, Chair.
Thank you, Mr. Lee. Sergeant, you have a question?
Sorry, Chair. Yes, thank you, Chair. Hi, Nick. Hi, Bianca. With regards to your client base, you did state that Bianca knows all the members. Is that correct?
Well, knows is a strong word. We have their names and addresses. In fact,
that's what I meant.
Yeah, indeed. And their details, their contact details, and their emails and what have you. That's how we publicise these niche events and get the bookings in before the event goes ahead.
Okay,
Mr.
so
Sampa, I'd like, sorry, Sergeant, but I'd like Miss Bianca to answer these specific questions and give us a bit more clarity on this one.
Yes, I do know some of them, members from previous parties that I've had and previous places where I've been working. So yeah, I know them very well. I know their families. We have a close relationship, just to say. We've known each other for years now.
And am I right, Bianca, that's all recorded on a database that you have at your direct disposal at all times?
I will have it. I don't have it at the moment because I'm not, I have their phone numbers and addresses, but I don't have a record per se, like a book or anything like that. I have it all in my phone and yeah.
Okay, and then with regards to the vetting or your client base, will you also then have their like ID or passports on your records as well?
Yes,
Okay, and the reason I ask is just, you know, sometimes with clubs and stuff like that, that is now kind of a prerequisite to have that digital identification to verify who is who, etc. Because say now I go in and I say I am so and so, but I'm not actually the actual person. It's just to verify that, and then again that just comes into my concern about the whole VORG element of that, which wouldn't necessarily fall your fault as such. But what
if I can just fill you in on the details. Members must be 21 years of age. Name and address, contact details are recorded on the membership form, along with a digital photo. New membership applications will be supported by nominations from pre-existing members, and there will be a membership fee. Thank you.
Thank you.
Sorry, Mr. Sampa, you just said there will be a membership fee, because that's not what's written on in the pack. Yeah. In the pack, it states that it's free. And that Miss Bianca actually decides who becomes a member because it's a friends of friends and people she knows. So
yes,
can please Bianca explain to us? I'd like to know from Miss Bianca about the membership, please. Can we get a clarification on this point?
Yes. So basically, all the members will have to apply for membership. It will take between 2 to 4 days to get an answer from me for their membership. They will have to also pay a small fee for their membership card. We will use
how much?
About £5 or just something like that. £5 for their membership fee. So yeah, it will take around 2 to 4 days to become a member.
So how many members do you have in total? Just a question.
To be honest, I haven't counted, but at the moment we would have around 35 to 40 members. Now they will have to pre-book a table before coming and let us know how many guests they will have as well.
So each member can bring up to 4 guests.
Yes, correct.
Okay. Sergeant, does this clarify your point, or do you have any further questions?
Thank you, Chair. Yeah, it does clarify. If I may ask one more question, if I may.
Yes, please go ahead.
So the 4 members that they bring in, would you then vet those yourself, Bianca? As
They
in,
will have to provide, so basically the active member will be responsible to let his members know about our policies that we have in place. To they will have to provide ID at the entrance, and they will have to write down in a book their address. They will have to provide ID, as I said, telephone numbers, and yeah, that's how we will.
So those will then, so those members that aren't those people who aren't members who come with the member will then have their details recorded.
Yes.
In a book, right?
Yes.
Will that then be on your database per se,
Yes.
with regards to prospective clients in the future?
Yes.
Okay. All right. Thank you, Chair. Thank you, Bianca.
Thank you, Sergeant.
Thank you, Nick.
I'll move now to Miss Mimi Stupu for her questions, if she has some.
Thank you, Chair. Just apologies, 1 second, I lost my question. I have one question regarding the noise report, and then I'll go back to what was discussed earlier that I want to ask another question. The noise report, I'll contest that later when I make my presentation, but I had a question based on this statement that's found in the noise report. For the patrons leaving the premises, the management can request the patrons to leave in an orderly and quiet fashion. How is the applicant going to manage patrons arriving or leaving the premises? As I said, there's nothing else included in a noise management plan apart from this sentence. But we have witnessed customers being dropped off on Greenman Lane or Knoxbridge Road on the Broadway. And I just want to know, how is the applicant going to manage any antisocial behaviour linked to an area that might be a 2-minute walk from the premises, and the SIA that's standing outside the front door would not be able to see that?
Okay, well, it's not, and yeah, I know, but I'm the representative, and if you'd let me just answer the question in the most general terms. Firstly, it is not for the SIA to police the public space. Okay. So what happens 2 minutes up the road? I've already told you, under the guidance, that is a matter for individuals under the law. As concerns dispersal, the SIA, the first impression, the last impression you get of a premises is the SIA staff. They welcome you in and they see you home. Okay, make sure you leave the premises in an orderly fashion. That is the role of the SIA. I don't know if that answer is sufficient. Maybe Bianca can help you further if you've got any supplementaries to that.
Yes, we also have notices put up on the walls to remind our customers to live in an orderly manner and think about our neighbours. I will also encourage them to leave verbally, to leave in an orderly manner when they leave the premises.
Thank you. I appreciate that, but how are you? And I appreciate what Mr. Semper stated, that they're not able to control and what happens in the vicinity, it's not their responsibility. But these patrons are associated with the use of the premises. We have witnessed, I would like to remind the committee that we have carried out observations and we witnessed people arriving at 1, 2 o'clock in the morning. This means this premises would bring people from other areas being dropped off in cars or driving there and causing an antisocial behaviour in other areas. And to be fair, those residents will not even know if it's associated with the use of that premises. If someone is being dropped off at 1 o'clock in the morning in an area that they won't think is associated with angels, they will not even report that, because they'll just think, oh, they're just some drunk people passing by and screaming and shouting. As we witnessed previously, we have witnessed that kind of behavior, people being very intoxicated, arriving at the premises and entering the premises. And that's why I wanted to know, how is this going to be addressed? Appreciate that,
Okay.
but
Okay, well, again, I point you back to the acting section, the guidance that says that behaviours that occur away from the premises, nothing within the control of the applicant or the premises licence holders, that people are responsible for their own behaviour. It's a matter of under the law. That's the first thing. Secondly, I'm not sure how many people will be turning up in a drunken state that late at night, because they have to be booked in and the entertainment is coming to an end at that time. And you know, you're talking about 2 o'clock in the morning. Well, the hours of this application are fixed. So you know, if somebody turns up at the end of the road, gets out of a taxi and they're drunk and noisy and haven't even got to the premises, that really can't be anything to do with Bianca. Okay, that's my take on that.
thank you. I appreciate that. Going back to what was discussed earlier about, and I appreciate that this doesn't come under public nuisance, but I do have a question with regards to the number of people arriving at any time. It was mentioned that a member can come with, or can bring 3 or 4 friends, or I assume friends. I would like to remind the committee that on the 5th to 6th of May, on the night of 5th to 6th of May, we carried out observations between 11 p.m. up to 2:15. And between that time, we actually witnessed, there were multiple incidents witnessed, but there was an incident where we witnessed, sorry, I just lost it now, because we witnessed 8 males arriving at one time. How is that? It doesn't, I doubt those people know each other from just being members, and they decided to arrive 8 people in one go. How is that managed?
I can deal with that. You are looking back at a premises that was subject to no premises license at the time. It was operating under a temporary event notice, and none of these conditions that we've offered applied. Okay, so they've actually done nothing wrong back on the 18th of May. Okay, and if we were to go into camera, I'd like to address you on the directed surveillance that has been conducted on the premises, maybe in private. I think it's not the place to go for. It's not necessarily
it wasn't direct surveillance. We were carrying observations, as you can see from our notes. It was the entire area. We witnessed patrons going into other premises. We didn't make reference just to the Angels. We witnessed other incidents. It wasn't just, we're not targeting the Angels Club, if you would like me to address that. We have received complaints, and we had temporary event notice applications. And as you know, as a public nuisance, we do have a duty of care when it comes to making sure that those temporary event notices or temporary events were carried out without causing a nuisance to residents.
Okay, right. Well, if you want to go there, we will. I didn't necessarily want to, but from reading the representations, it looks very much that from the 26th of April to the 18th of May, these premises were subject to directed surveillance from Elephant Civilian Council. Whether other places, whether it's part of a general patrol, but whether it was directed. Now, directed surveillance means
we have a noise patrol that operates out of hours.
You've raised it, so if you don't mind, I'll just address it. Now, directed surveillance means covert surveillance other than intrusive surveillance, where if this is in relation to a specific investigation or operation carried out to obtain or likely to obtain information about a particular person or persons, whether or not they've been specifically identified for the purpose of the investigation or operation. Now, local authorities do have powers to authorise directed surveillance, but only to prevent and detect certain types of crime. These include crimes where the maximum penalty of imprisonment is 6 months or more. So that rules out the entire Licensing Act of 2003, for which the maximum penalty is up to 6 months in prison or an unlimited fine. And secondly, crimes relating to the sale of drugs and alcohol to children, that's your test purchase operations. Now, any directed surveillance carried out must be for the purposes specified in an authorisation and not for any other purpose, sorry.
Mr. Semper, I must stop you here, because we're not now reading from the licensing policy. It's a simple
That's that-
question.
No, it's
And
not. It's not. It's
I
not
believe
licensing.
He's
Ma'am,
referring
The
to
okay.
nuisance team do have a duty to make sure that crimes and antisocial behavior does not happen in the borough. So we're not
Ma'am,
here to criticize their
I'm,
job.
I'm not here
Um,
to start. What I'm saying is, it appears from the thing, from
Yes.
from the reps,
Yeah.
that there has been directed surveillance, okay, on these premises,
It's
amongst
not
other
direct-
things.
It's
Okay,
not
no, you
direct
say it.
surveillance.
You say it isn't, but it's not actually your decision. It's whether it's directed within the terms of the regulatory Regulation of Investigative Procedures Act of 2000. Okay, and that I don't want to make a big fuss about it, but I have got some issues about whether that was lawful and whether this evidence is lawfully obtained. But anyway, look, I'll leave it there. I've made my point.
Yes.
And it's something for the lawyers to take up at a later date, no doubt. So thank you very much. Thank you.
Thank you. Miss Mimi, do you have any other questions?
No, I just wanted to address Mr. Semper's point with regards to lawyers and the legal team. We have made inquiries regarding that, and this was covered that we did not need RIPA. As I said, it was not direct surveillance. Our team operate. We have a noise service until the early hours of the morning, and it was part of one of the. I don't know if you've read my representations, but I'm not making reference just to the Angels, making comments about other people arriving or also other premises, such as the customers that were going to Angels. They stopped to get some food, and not just the Angels, it was for the entire area. It's just to monitor the antisocial behavior for that area, and but said it's not direct surveillance.
Okay.
That's all from me at the moment. Thank you.
Thank you, Ms. Tupper. I'm going to move now to my fellow councillors. Do you have any questions? Councillor Martin, Councillor Nakpal?
I think Mrs. Chapman wants to ask a question.
Oh, yes, of course. Okay, so let's ask Ms. Chapman, please, to ask her questions.
Thank you, Chair. I want to move perhaps onto a slightly different area, but it's related to operational hours. And I've got 2 or 3 probably related questions, which I'll ask Bianca, 1 or 2. I'll ask them one at a time, but directed, as I say, to the applicant. Bianca, are you aware of the conditions that apply to the premises under your planning permission, and could you tell us what they are?
Yes, I am aware of the planning conditions that we have. We are at the moment contesting that decision, and yes, I am aware, and with all due respect, Ms. Chapman, we're dealing with a premises license, not the planning application, but I am dealing with the planning decision as well.
Thank you. I'm very well aware that planning and licensing are 2 parallel regimes and can have different hours. Very well aware of that. But my question is, given that you say you know that your planning under planning your hours are restricted, your attempt a variation planning application to extend those hours has been refused. So planning clearly still believe there is an issue there. There is a further regime.
Councillor Backlin, you're on mute.
Oh, sorry, excuse me. Yes, I would like to ask Ms. Chapman to focus on the licensing objectives, please. If you have any questions in relation to the licensing objectives, please.
I do. The next guy, I was just going on to this, that the council's licensing policy, which is there to uphold the licensing objectives, also has recommended core hours for licensed premises. And again, I appreciate this is not mandatory, it's recommended. Your application is significantly in excess of those core hours. My question is, why are you applying for something which is deemed by the council not to be supportive of the licensing objectives, and I would say also is likely to be a problem to local residents?
The core hours are advisory. Okay, it's not set in stone. It's not law. Okay, I know you did. Okay, And therefore, after you step outside the core hours, if you want to go beyond the core hours, you have to address the likelihood that the licensing objectives will be not promoted or undermined. Okay, so we have done just that. That is the whole operating schedule. This is not a banging nightclub or a Wetherspoons or what have you. This is a tiny basement club for 31 people plus staff. And under the control measures that we're proposing, and under the advice, the contents of the noise report, which is expert, I would venture to say, evidence, we do not believe that we will be likely to undermine the licensing objectives, and therefore that's why we've applied. Thank you.
Okay, thank you. You've answered the questions. I'll come back to this when I make my representation.
Thank you, Ms. Chapman. Mr. Dyson, please ask a question.
Thank you. Two simple questions from me. One, I'm confused, Mr. Alenkai. Sorry, Ms. Alenkai, I'd love you to address this membership point because I'm confused. On the one hand, you said that you don't have a list of members, but on the other hand, you've said that you have 35 to 40 members currently, or certainly you've insinuated that. So which is it? Do you have members currently or do you not?
She has members currently, but they're not on a database to the level that, because just starting, this grant application hasn't been granted yet. It's been operating.
Mr. Semper, can we give an opportunity for Ms. Bianca to answer the question that was directed to her, please?
Yeah, my answer is the same as Mr. Nick. So basically, we do have, as I said, I know the members. I've worked with them before. The fact is, I do not have a specific book with their details to, at hand at the moment, because I'm not trading. I didn't feel that was necessary to put down for today's hearing. Mm-hmm. But I do have their contact details. I have their mobile numbers. So yeah.
Thank you. Yeah, my observation is simply that a simple list of members would seem to me the mere basics that you would have of membership. My second question is relating to the sound engineer. Can you please confirm if the sound engineer visited any of the potentially impacted properties in the immediate vicinity? I'm certainly not aware of the sound engineer visiting the block directly above the basement flat in question, which would be most impacted by noise.
Mr. Dyson, no, I can confirm that he hasn't visited the premises above. I'm not sure that he needs to, because his inspection of the premises suggests that there will not, well, stronger than suggests, really, suggests that there will not be noise leakage and nuisance emanating from the premises due to the construction, the thickness of the walls, and what is proposed therein. Thank you.
Thank you. I'll refute that in my own representation shortly with the evidence of my own ears. Thank you.
One thing I just need to clarify as well, in between the residence flats and the basement, there is a 24-hour casino that operates 7 days a week. So yeah, that works.
Absolutely, which is silent. There's never been a noise nuisance from there. Thank you.
Thank you. I can see Miss Mimi Stupu has a question.
Sorry, Chair, just a quick one. It's similar to Mr. Dyson's question, to be fair. I was going to address this in my representation, but I wanted to ask a question before I address that. It was with regards to the noise management, well, to the noise management report. Who was anyone present? Was Mr. Semper or Mr. Alenkai present when the sound engineer attended and carried out this noise report? And like Mr. Dyson said, I wanted to ask about if he visited any residential or the premises that are going to be affected.
I can answer. I wasn't there, no, but the expert evidence speaks for itself. If you've got expert evidence of a comparable level to place before this panel prior to the hearing, that was the time to challenge that, because we could have gone back to the chartered engineer and the expert in acoustics, and we could have had at this hearing a battle of acoustic experts.
Mhm.
But we heard nothing from you.
I appreciate that, but it's the evidence that you provided, and you've stated that he's an expert. So I do expect a report to be of the same value. I will raise that in my representation. It's not my position to give advice on a noise report. If you qualified someone, if you employed a qualified engineer, it's not within our remit to give you advice or which person you should employ.
Yes, but if you wish to challenge the expert opinion, then you would serve expert opinion on the panel, on us and the committee prior to the committee. So we could go back and we could clarify any issues you had with the nature and content and quality of that expert evidence. And this you have failed to do, with respect.
Okay, I will raise that in my representation. Thank you.
Ms. Bianca, you wish to speak?
Yes, I would like to ask Miss Mimi.
I think you could ask her after her representation. Thank you. I'll move now to Councillor Nakpal. Do you have any questions?
Yes, thank you, Chair. Ms. Alenkai, how many dancers do you have on present in a typical night, please?
How many dancers do you have in a typical night?
It can be around 2, 3, maximum 4, which take turns in their performance.
4 dancers at a time. Okay.
Yeah.
So you have 4 dancers, 2 bar staff, self, and an SIA agent, and 31.
Councillor Nakpal, we can hardly hear you. If you can move closer.
Yeah, and my apologies. You have 4 dancers, 2 bar staff, yourself, an SIA agent, and 31 guests.
If I have 3 dancers, then obviously the number of the guests that will be admitted will reduce. So in total, we're going to have 35 people inside the premises at all time, because not all the guests will book tables at the same day. So they usually it's between 5 to 10 guests, 5 to 10 members, 5 to 10 people. So it very rarely gets to 20 members and guests inside the premises. Very rarely.
Say very rarely, but you've also said that you know in advance who's attending and how many are attending.
Of course. Based on that, based on the bookings, I can then hire, book the performers based on how many bookings we get.
Okay. So do the guests tell you in advance what time they'll be arriving and what time they'll be leaving?
Yes. No, they will tell me an approximate hour where they can attend. And they will also let me know how many guests they're bringing. So yeah, but we do have a policy in place that everyone should be there before 1 a.m. So last entry is 1 a.m.
Okay, but presumably you know beforehand who is arriving before 1 a.m. if everyone's pre-booked.
Yes, if you do not pre-book, then you can't enter the premises.
Okay, can you explain how that's monitored, please?
How that's monitored?
Monitored.
So if honestly, I don't understand the question.
So how do you monitor who's come in and who's left, and therefore how many people are left in the premises?
Well, the SIA will be responsible for that, and as we said, it's a very small premises. It's only one room in the basement. We can monitor easily that.
Yeah, SIA usually use clickers, Councillor. You click one up, click one down, people coming in and out. But there will not be this foot flow of people coming in and out. You've got to sorry, I'm just waving my hand down, destroying the image. We know how many people are coming. because they're booked in and we know what time the entertainment's going to start. And she's given you the last entry hour of 1 o'clock. Thank you. Good question.
So just to clarify then, does he use a clicker or does he have a list of who's attending? I just want to really get a detailed understanding as to exactly what happens, please.
When they pre-book the tables, we know exactly who comes, what time they will come. So they will give me like in between 7 to 8 or 9 to 10. They'll give me a specific time slot when they will be arriving, and that's how we will know.
Okay, so when you say they'll give you the details, are you at the door checking those names? I'm just trying to understand what unfolds on the night when they arrive. Is it you? Or
I'll explain, and I hope this will make everyone understand how we operate a little bit better. So when they are outside the premises, or they'll let me know that they're coming, they're on their ways, it's either me or my partner who goes outside and welcome the guests. And then we get a chance to see how intoxicated they are, who they're bringing, if, you know, are they banned from the premises or not. So yeah, it gives us a chance to really see and understand who's coming to our premises.
Okay, so you or your partner will be outside with the SIA guard at all times to vet who's coming in.
It's not at all times. It's whenever we get the phone calls to tell us that they're outside the premises.
Okay, so when you say pre-booked, do you mean somebody calls you in advance to say we're coming in an hour, or do you actually have somebody pre-booked, say a day beforehand or 2 days beforehand?
They can book on the day or the day before, a few hours prior.
But they can also call you an hour beforehand and say we're on our way.
If they do that, then they'll not be allowed inside. They have to pre-book or a table.
But you just said they can call you and tell you if they're on their way.
Yeah, but that's to let me know that they're outside the premises. When they're already booked, they will call me to say I'm outside, and then I'll go and you know, call them inside. Or
okay. Do you have a staff area?
Sorry.
Do you have a staff area?
Staff area.
Staff room.
No, we don't. As you can see in the plan, it's a very small venue. So we don't have a staff area now.
So where do the dancers sit in between performances?
They will sit on the sofas that we have in the premises.
So
it's a separate sofa that's next to the bar. That's just for them to sit. Okay. And no members are allowed to sit there. Okay. It's just for them.
So at no point will the dancers be sitting among guests?
No.
Okay. And in your representation, you've said that a room will be provided for dancers to change in if they require it. Can you give me a scenario where a dancer may not require a room to change in?
If they require room for changing, I can't provide that because they will have to change in, as I mentioned before, in the ladies' toilet.
Okay.
The planning, I can't change the plan, honestly.
Mm-hmm.
Okay,
but you've also
I have to apply to the planning commission.
Yeah, you've also said in your representation if they need a room to change in. So is there ever a scenario where they don't need a room to change in? I didn't understand the purpose of that being in the representations.
No.
Perhaps Nick can help you here?
Yeah, perhaps.
You're on mute.
I've got it. I've set the hairs running with that one, haven't I? What I meant to say is a private area, and that would be the ladies' toilets if they need to change. So Bianca tells us the the dancers don't turn up in their traditional dress, or if they, so if they need to change there, they'll be afforded the facilities of the ladies' toilets.
And so, if you could kindly clarify, if there's ever a scenario where a dancer doesn't need a space to change in, as has been stated in the representation.
The scenario would be where somebody turns up already attired in their dance, in their dance costume, ma'am.
So you said if they need a space to change in, not if they've come dressed.
Yes. I'm sorry about the phraseology of that. Yeah, you've raised a good point. Thank you.
Okay, so presumably a dancer will always need a space to change in.
Bianca, can you tell us what usually happens, please? Because the council is particularly concerned on this point.
Yes, so usually what happens is the performers come beforehand, they get changed into the toilet, the ladies' toilet, and they come and sit down on their space, their couch, and that's about it.
Mm-hmm.
Okay. I think you mentioned earlier that the storeroom doesn't have CCTV.
The storage, as we're in the basement, the storage is like there's nothing there. It's just walls and water pipes, and it's nothing there.
I mean, from the maps, it looks like a significant space. I mean, maybe even
it's a storage space. It's not actually a room. I think the cupboards are off the floor, aren't they? You can't walk in there, can you? It is a storage. You can't physically walk in there, councillor, because it's a door in the wall, okay, and behind that's where the drinks are kept and whatever, decorations for particular events. That's where you'd store things like that. It's not a walk-in room. No, it's a cupboard basically.
Yes.
So a person couldn't physically fit inside the room.
I think you could squeeze somebody in there, but no, you couldn't easily access that and go in there. It's like I say, it's off the floor. It's a couple of feet off the floor, I believe.
Yes.
I haven't visited the premises, so I just felt we need to clarify. So you have no CCTV facing the storage area, is that right?
The storage area is behind the bar.
Okay.
And I don't have any CCTV. I have it behind the bar, facing all the entire floor. But the storage is basically a cupboard, to be honest.
If it's a concern for you, councillor, bearing in mind there's so much CCTV down there anyway, we'll put a CCTV camera inside the storage cupboard, if that would give you the reassurance you're after.
It would indeed, particularly because it's been stated that the entire premises is covered by CCTV. In fact, we've relied on that quite a lot. So it would definitely give me some comfort if that was in fact the case.
Absolutely, no problems. No problems.
Okay.
Maybe Mr. Kassar can help us because he's been to the premises. He can explain a little bit better how that cupboard is.
If you're happy to put CCTV there, then that allays my concerns.
Bianca, you're frozen. Bianca, A, you're frozen, and B, it's not your job to ask Sergeant Kassar yet. Okay, we'll do, let the chair run the meeting. Okay,
and I think
I apologize.
So Miss Bianca, you are happy to add an extra CCTV near the storage area?
Yes.
So we could add this as a condition.
Brilliant.
If the application is granted.
Sorry, just a couple more questions. As part of your evidence, you have provided a photograph of what looks like a door, a fire exit door, and it has various posters on there, one of which is titled Staff Guidance. Where is that located, please? I assumed it was the staff area, and
yes,
there isn't one.
That's at the end, so it's opposite the bar. We have already installed CCTV behind the bar, which faces that door. That is, as I said, again, a very small, narrow space which has like the water meter pipes that goes for the whole building. So you can't fit a human being there. You can't.
Okay.
It's so small.
Okay. As part of your representations, you've also stated that if somebody is refused service of alcohol, this will be documented. Can you just give me a brief rundown as to if you've only got 2 bar staff and a number of patrons waiting to be served? Can you tell me how you would document that in a timely manner to ensure that you are not missing anything?
Yes, we will have a incident logbook at the premises.
I'm talking about the log that refuses drinks.
We will have a similar book to record everything, every incident, every refusal, entry refusal.
Yeah.
We will record everything. Yes.
Yeah, ma'am, as concerns that bit which is in para E, that's to do with people who are unable to that specific written register refusals. That refers to people who are unable to provide proof of their age, reference challenge 25. But
Yes.
the refusals of drunks, that's captured in the incident book, which you've correctly identified, and that is in section
Yes.
section B. Okay, so there we go.
So if a client was particularly inebriated, would you continue to serve them drinks, Bianca?
No, of course not. I'll give them water.
Okay, and would you log that as an incident? Just clarifying what
I would
be an
record it.
incident.
Yes, I would write it down in the book. Yes.
Okay. I think this should be my last question. In one of your statements of truth, one of the statements of truth provided rather, it is stated that on one particular occasion, one of the guests was dancing with one of the dancers, but you've also stated that it's a very small space, and you've also stated that guests would have to remain 3 feet away from the dancers. So can you just explain to me how you would manage that situation if a guest decided to get up and dance with a dancer?
Yes, if someone decides to get up and start, dancing or get near the dancer, we will have to go and warn the customer that we do not tolerate such behavior. We do not tolerate anyone close to the dancer, and we can always take their membership away, or we can always take them outside then and there.
So to clarify, is it part of your rules and procedures that guests cannot get up and dance with dancers?
Exactly.
It's okay, because you haven't made that representation anywhere, but you have given a statement of truth to say that somebody has got up and danced with a dancer, albeit in a very friendly manner. You have stated that he's done that and nothing was done to stop him from doing so. It was sort of almost, everybody sort of smiled along as per what was suggested in the statement of truth.
Ma'am, can you direct me to the extract of the statement of truth you're referring to, please?
I think it's from the SIA agent. If you bear with me a second, I'll find it.
I can deal with that. It was a Bhangra song, and usually with the Bhangra songs, they dance like not together, but they dance near. Like in a, how do I say this? Like in a, they dance near, not near, next to each other. So they dance together to the specific song. But
sorry, Miss Bianca, who dances together? Because we're now confused. Is it the dancers or the person in question who got up and started dancing?
The dancer dance together as an act.
Okay, but you didn't answer Miss Councillor Nakpal's question.
It was about the representation, isn't it?
Yes, it's about in the letter of truth from the SIA, where he stated that at one incident, one of the guests stood up and started dancing.
Okay, yeah, we dealt with that accordingly, and we told the customer that he's not allowed to do that. He was actually a guest of a member, so we told him he cannot do that. If he does it again, he will have to go readjust that.
Just to point out though that was not in the statement of truth. The SIA agent suggested that he was permitted to dance because he wasn't doing anything untoward, so he was permitted to dance with the dancer. But you've also said that you wouldn't permit that and that you indeed told him to stop. Just clarifying which of the two it was, because he's signed that it is a statement of truth.
Let me just come in on that. Let's read what he actually says. Where is it now? Stand by.
Mr. Semper, I'd prefer if Miss Bianca could answer this question, because she was there at the night and
but we need to understand what the guy's actually saying. He says he can remember on one occasion. I just need to dig it out. I won't be a second. Yeah, I saw a customer in both types of entertainment. It's the rule that customers cannot touch the dancers. I saw a customer dancing with a dancer once in Bollywood Bhangra style, but not close or touching. This type of dancing is traditional Punjabi style, and when they dance beside each other, but not closely touching in any way. In that passage, the witness does not deal with how or refer in any way as to how Bianca dealt with that incident. And Bianca's told us how she dealt with that incident. It's just that he's saying that in that month of operating under those temporary event notices, he saw one guy stand up once and dance beside but not touching. I think he was addressing whether touching goes on, but whatever. You've heard Bianca's explanation of how she dealt with that incident, ma'am.
I completely agree with what you're saying, Mr. Semper. All I'm pointing out is that if he's a security agent and he's coming from that angle, I would expect for him to focus on the fact that Bianca immediately dealt with the situation and asked him to sit down, and that's perhaps a procedure that you follow, but nothing of that effect has been put in the representations. Also, beside each other seems quite far removed from 3 feet away, and I just wanted to clarify that as well with Bianca.
Yes, and that's right. And Bianca doesn't tolerate people dancing with the dancers, and therefore that's why we've offered the 3-foot rule. So I'm glad you've underlined that. Thank you.
Okay, Councillor Nagpal, any further questions?
That's it for now. Thank you, Chair.
Thank you. I'll move now to Councillor Martin.
Thank you, Chair. Councillor Nagpal has covered a number of questions I had. I'm just still a little bit unclear, and maybe this just might be me. The premises is very small. Have we got one toilet or 2 toilets here? Is it a unisex toilet? Are the women going to be changing? What's the situation here?
Yeah.
Just so I'm very, very clear. And can I address that to Bianca, please?
We only have one toilet, but we are planning to build another toilet in near future.
Okay, so we've just got one toilet. So when an entertainer attends the premises and the toilets are occupied by a male, how do you deal with that situation?
The entertainer will have to wait until the toilet is clear. Myself or my partner would go and check or that the toilet is safe for the performer to go and change, and then someone will make sure that we also have a lock inside the toilet where the dancer can change and she can be safe whilst changing.
Okay, I'm glad we've cleared that up, that there is just one toilet facility. Could you provide the group with what the 4 licensing objectives are that underpin the Licensing Act 2003, please? Okay,
we have prevention of crime and disorder. prevention of children from harm, public nuisance, and public safety.
And protection of children from harm, yeah?
Yes.
Yeah, she mentioned it.
Yeah, which is fine. How do you feel, or how do you believe you can deal with incidences? And I know that Mr. Stemper will come back with something on this, but how would you deal with a situation where you have an incident outside your premises between the hours of, say, 3 and 5, with school children who use this area on a regular basis to come home from school and to use the high street? How do you believe that you can deal with an incident where you've got, if I recall correctly, one SIA on board who's got to basically be upstairs, who's also got to be downstairs, who's also got to be dealing with any particular incident? How would you deal with an incident that would happen outside with one of your members or their guests, i.e. that they turn up, they potentially are drunk, there is, or inebriated in any shape or form? How do you feel that, and how is that going to be dealt with?
Well, my partner is going at the moment through a SIA course. So he will be present as well. So we will have basically 2 SIA trained people at the premises.
Can you confirm whether there's CCTV outside the premises as well, please, Bianca?
Yes, we have CCTV as well, facing both Uxbridge Road and the car park.
Ms. Bianca, I'd like, sorry, you mentioned your partner twice now. Is he a staff member already? Is he a bar staff member? What is his
No, he's a business partner.
Business partners, thank you.
He owns the catering company, which owns the lease of the premises.
Okay. Councillor Martin, do you have any questions?
That's it for the moment, Chair. Thank you. Yeah.
Thank you. Well, I have one more question. Why do you need after 11, between 11 and 2? Why do you need this extension of hours? Couldn't the performances be from 9 to 11, from 8 to 11? What's the specific reason behind this timing, please?
The specific reason behind this timing is because we are members only, and we do not have the possibility to welcome people from the streets, anyone, not anyone can come in. So therefore we have to prolong the hours of trading in order to be able to, support the business. It's simple as that.
Just like that. So going again in terms of dancing performances, are they going to run from 11 p.m. or are they running before 11 p.m. or it differs?
It differs. It depends on how many bookings we get. It differs on the day. It differs. So we do not start per se at 11 o'clock. We can start from 6 o'clock or 8 p.m. It all depends on the day, honestly.
So if you start from 6 p.m. until 2 a.m., how many dances would you have like in a day?
As I mentioned, it's between 1 and 2.
I know. Okay, so if you have a very successful event, you will have up to 4 dances from 6 p.m. up until 2 a.m. Okay, thank you. I don't see any further questions for the applicant. In this case, I will move and ask the police to give the representation, please. Oh, Kim, sorry, Councillor Kim.
Sorry, Chair, just one last question.
Yes.
It may or may not be relevant, but I want to ask just to get a better sense of the situation. One of the statements of truth was provided by somebody who owns a company that provides dancers to you, Bianca. How long? It says a few months or several months. How long have you known that individual, please?
oh gosh, I met back in March, I think.
March, April 2023.
24.
24. Okay. Do you know much about her company? Do you know how long she's been
on
operating?
Company House. I know she works for different types of events and premises all around London. I've checked her company on Company House. So yeah, I know she's 100% genuine.
You're confident when you recruit dancers through her company. You're confident that it's a good company and that she's operated to a good standard.
Yes. She's not the only company we will work with. As I mentioned before, we've sent already some of the websites that currently offer dancers or performers for events. There are lots of them in Ealing as well, Ealing, Harrow, all over London. So, yeah.
So what's your standard process of vetting a company that you obtain dancers from? I mean, how do you know that it's a reliable company and that their dancers are treated well and paid well and are not overworked or what have you? How do you vet that, if you don't mind asking?
Honestly, if they were overworked or not paid well, I don't think anyone would still work for that company. But if there's always reviews that you can check with their reviews online. So yes.
So your process of vetting is checking reviews online?
Yes.
Yeah, ma'am, we do our best. We put in we only want to deal with bona fide ones. You know, we're not the police. We can't Google these people on the police national computer. You know, a lot of this is reputational based, and like I say, we've served on you websites where you can obtain, you know, performers to do this kind of work. I mean, you know, I don't know how we can help you further, but apart from to assure you that we do not intend to work with disreputable providers of performers.
Okay. I didn't suggest that you did. I just wanted to clarify from Bianca that she takes something like this seriously. Because having looked at the Company's House website, the last set of accounts that company submitted were in fact dormant. So I just wanted to understand how long they'd been running and how established they were and how well they'd set up their processes. That's all. I'm just clarifying how seriously she takes that situation.
Thank you, Councillor Nakpal.
Thank you.
Okay, Sergeant Kassa, if you could please proceed with your presentation, please.
Thank you, Chair. Thank you, everyone. As you are aware, I have put my written representation into the pack that I'm sure you've all read. Yeah. I don't want to go over old money, as it were, but from a policing perspective and just based on what we've heard today, in terms of the venue itself, PC Hewison and I attended the premises and met with Miss Allenchai and her husband Octavian. Is that correct? That is correct, Bianca. Your husband's name is Octavian, is that correct? Or your partner? Yeah. We were showed around the premises, which is small with benches along the walls and a small square tables in front of the benches and a small bar at one of the end. We've heard in the hearing today, in terms of various questions that have been posed to Ms. Allenchai, is that the venue is very small. From a Vaughan perspective, police are concerned that there is only one toilet in that small venue. And the reason I say it is a Vaughan concern is because it is a very small venue. If it is there for men and women to utilise, I think it does compromise the safety of the dancers who are conducting a performance at the venue, if that makes sense what I'm saying. Whilst I haven't got any evidence to prove or disprove that, it is a concern because it is quite narrow getting out into the area. The other concern I have in terms of the whole VORG and that crime and disorder element, which is one of the licensing objectives, is in terms of the space, it is quite small and narrow. And it was alluded that the dancers who aren't performing would have a specific bench to sit on, but that is not delineated in the plan of the actual venue, if you look at it. So from my perspective, again, it would appear, and I can't prove or disprove that they would potentially be sitting in between clients. So again, it does blur that line.
Sorry, Chair, I don't wish to interrupt, but we do have Mr. Stemper and his client have disappeared off the screen. Oh, okay. Bianca's back now.
Okay, sorry about that.
Sorry.
No, that's all right. I am aware that we have already discussed the genre of dancing that will be taken part, which is Bollywood or belly dance type. Now, I'm not exclusively saying that these are of a sexual nature, but from my understanding, there is a level of eroticism attached to these types of dances. So from a metaphorical perspective, I'm not talking about a physical perspective. And again, coming to that violence against women and girls, I do feel that if it is from 11 till 2 o'clock in the morning, it's late hours, it's a private members club of which mostly are male. Again, it is just a concern I have that this may be not quite what it appears to be, but I'm not trying to be accusatory. It's just a police belief that we are concerned about this, again, falling on that violence against women and girls. So the long operating hours till 2 in the morning does create or cause concern for us. Again, in terms of vetting the dancers and their agent or talent agency that they will be drawn from, I am concerned, again, as you've alluded to, Ms. Councillor Nagpal, regarding the Companies House, which you stated. I am a bit concerned that that company's gone dormant. So where is a reputable talent agency? If you work for a talent agency, whether you're an actor or a dancer or in that entertainment environment, you should have an agent or a representative to represent you. I understand the machinations of this because I did work in the entertainment industry. When you employ somebody, you sign a contract. Where is the contractual obligation between the agent and Miss Alan Chai in terms of those dancers, which for me would then, again, that concern regarding violence against women and girls. And again, I'm not being accusatory here, but it is just a concern that I do have, because if you have a reputable agent, they will safeguard and look after their employees, which would be that performer. So in line with what we have discussed today, I do have concerns regarding this. And yes, West Ealing, as we know from a policing perspective, whilst I'm not saying that Angels Club is a contributory factor towards this, but it does have that high level of antisocial behaviour. We are aware from the various neighbourhood teams that there are street drinkers, there are drug users that constantly frequent that area, and I'm aware from the residents they do cause them untold amounts of chaos and public nuisance. So just linking the venue to that, again, I'm just concerned with those late operating hours. And whilst I do understand that there is going to be a list of attendees or members, as Ms. Alan Chai and Mr. Semper have stated, when they leave, and again, it's not down to them to police that, but it just leaves those women in a vulnerable state. So these are just my concerns I have from a policing perspective and responsible authority. And you're right, Mr. Semper, I do not have the hardcore evidence to clarify that, but my understanding with regards to these hearings, it's also on a balance of probability. So, Chair, councillors, and everybody attending this, these are my concerns, and I put that forward to you. Thank you very much for your time.
Thank you, Sergeant. Mr. Semper, you are, we can't see you. Your screen is gone. Mr. Semper?
Hi, yeah, I'm still here. I'm still here listening, making copious notes actually. I'm just trying to make sure the bandwidth, because we had some people chopping up before, and obviously if we cut the amount of imagery on the screen.
I will now move to see if you have any questions to Mr. For Sergeant.
Yeah, indeed. No, I haven't actually, because I can deal with it all in summary. So I'm very conscious of the time. We can deal with those concerns in summary, ma'am. Thank you.
Mr. Pooh, Councillor Dear, Mr. Dear, Councillor Martin, Councillor Nakpal, do you have any questions? No, in this case,
thank you.
I'll move to Mr. Bob Dear to give his presentation from the Licensing Authority.
Thank you, Chair. I'll leave the camera on until I freeze, or if somebody lets me know if I happen to do that.
No.
Yes, we've heard this is the second application by Bianca.
Oh, it has frozen already, Mr. Dear.
Can you hear me, Chair? That's the main thing, I suppose.
That's better. I think, without
a lot of people don't want to see my face, so yes, this is the second application. The hours have been reduced to 2 o'clock from 3 o'clock. Obviously, I say that the hours are still proposed, are still excessive and outside the London Borough of Ealing's core hours, which, yes, they are advisory, but they've been put in the policy for a reason. We're not talking about a town centre in West Ealing. It's a small area that, as mentioned by the police, suffers heavily from street drinkers and antisocial behaviour. This is described as a members only venue and permit each member up to 4 guests. But with that capacity of only 31 plus any staff, or even 30, depending on how many dancers we have, it will fill very quickly, leading, I'm afraid, there will be queues, because unfortunately people don't listen. We all know that. People will turn up and they may be turned away, but in a 250 metre radius of this, there are other licensed premises that close at midnight and 1 o'clock. And as I've said, yes, they may turn up the area. We're not just talking about the community from the South Asian community, that, as was mentioned in the previous application, and certain parties would be excluded, cultures. Now, the couple of points I want to make is the doorman, SI Security. It states it will be on a risk assessed basis. However, as stated in respect to premises reach the capacity suddenly, who would actually manage any gatherings outside? We've heard actually that Bianca's partner is in the process of taking a license, but the premises will not be able to call on other security because the company that they've employed, or this guy comes from, that we've heard a statement of truth, is in Essex. The venue being the basement, only one entrance. You're going to need a minimum of 2. I still stick by that. Yes, the standard, the agent's standard says 1 to 75, but obviously other things have to be taken into consideration in that risk assessment. Complaints, I understand, have been received, and obviously we've heard that the 3-foot rule, which I have mentioned, quite rightly Mr. Semper picks up, is old-fashioned, because that was back in the early 2000s. That was that rule when these dance venues used that, especially in Westminster. So my application, my representation still stands. I still say that the hours are excessive and it should be refused. I don't believe there are any other conditions. We've heard that wave training has been taken on. Well, wave training has been taken on, and it mentions security and their role in making sure people leave the area quietly. Vulnerable people are looked after when they leave the venue, it says as well in that training, because I've done that training as well. So I say refuse, please. Thank you.
Thank you, Mr. Deere. Ms. Stupe, would you please start your presentation?
Thank you. Just give me, sorry, apologies. Thank you, Chair. I'd like to address the matter concerning the noise report. Mr. Semper claimed earlier that I didn't get in touch with them to challenge the report, the noise report. As I mentioned earlier, if a qualified sound engineer had been employed, we'd expect the noise report to adhere to a certain standard. I don't know if I assume Mr. Semper is aware, but the objectors received the report on Friday, 23rd of August, while the report itself, the noise report, is dated 2nd of July. And in my opinion, the applicant had plenty of time to send the report. If there were any concerns, they should have contacted me. With all due respect, Monday was a bank holiday, and leaving me only with Tuesday to review the noise management plan, as I did not work yesterday. As I said, if the applicant had concerns about the noise report and wanted to ask for my opinion, I think they had plenty of time from 2nd of July until now to contact me. With regards to the noise report, it's not satisfactory. No measurements were taken from any residential properties to assess the potential impact on nearby residents, and this was also confirmed by Mr. Dyson earlier. The report assumes that the noise report assumes that the Mercus lots, the premises which is located above Angels, will act as a noise buffer along with the furniture of Angels Club. Based on my 12 years of experience in environmental health, I can assure you that vibrations, noise and bass and everything else can travel up to 10 stories for the building structure. So as I said, I'm not satisfied with the noise report. There are no noise measurement or apart from making reference to a sound limiter by the music. But I'd also like to remind the committee that when we carried out these observations, we did witness music and also people cheering and shouting loudly in the premises. Again, going back to the report, I'm not satisfied because it's not an acoustician report. It's not acoustic. It doesn't make any reference to acoustic apart from the envelope of the building. With regards to Mr. Semper stressing that the committee should consider real evidence and evaluate this application on its own merits, I appreciate that, but I would also like to remind the committee that I have provided ample evidence of the noise witnessed by our officers on pages 50 to 52 of the agenda pack. Mr. Semper insisted that the committee should disregard this evidence. He also mentioned that antisocial behaviour linked to patrons arriving and leaving the premises is not the applicant's responsibility, which I totally disagree. It's not fair on the residents that live nearby. As I said, we witnessed people being dropped off or arriving not outside the premises, so not just those residents that live directly above would be affected, but also residents in the nearby vicinity. And as Mr. Semper stated, it's not the applicant's responsibility. However, this behaviour was witnessed by our officers, all those concerns. Mr. Semper also stated that the committee should not take the previous observations into account. But how can we ignore incidents that we witnessed on the 20th of April when officers witnessed antisocial behaviour, and there were two other incidents that we carried out observations for that area. Going back to noise complaints, Mr. Semper also stated that if there was an issue, the residents would have bombarded us with complaints. I strongly disagree with that statement. Some residents may not complain, particularly if they're tenants or if they have a short tenancy, they might move out, and some of them are not even aware that we have their proper channels to complain. And as I said, working in environmental health for 12 years, I still meet residents like, oh, I didn't know we have a noise service, and they have no idea. So they will not be aware of our service or what they have to do. Plus, if patrons arriving at the premises and they're being dropped off further down the road, they will not know that is associated with the Angels Club, so we cannot link this. It will be reported as what we call street noise, but it will not be linked to the address. I just want to make the committee aware of the residents' representations. One of them, which was on page 69 of the main document, states that the residents have already had problems with this club hosting private parties and with sexual conduct from attendees. Page 63, again, another resident outlines concerns about antisocial behavior and disorder. Page 68, a resident noted that when the club was operating illegally, some residents moved out of their homes due to their noise levels. I appreciate that Mr. Semper said that the committee should only base this on evidence, but we cannot ignore these statements. And as I said earlier, yes, we didn't have any complaints and any noise complaints. But clearly the residents have been affected if it made them contact the licensing department to make a representation. So apologies, I'm just going through my notes. I'd also like to contest the statement made by the SI Security, which alleges that the incident witnessed by our officers on the 28th of April is incorrect. I find it hard to believe that our officers would lie and they'll make stuff up. The applicant mentioned that she knows some, so apologies, if the applicant made reference to this SIA that he witnessed the incident. But as I said, I find it very hard to believe that our officers would lie and make stuff up about an incident. And if they had any concerns, they could have approached the security. The security could have approached their officers. Apologies. With regards to the information that I provided in my representation, which wasn't really discussed, the information I obtained from Harrow Council regarding the premises with which the applicant is associated. The applicant also made mention that she knows some of these customers from her previous work, which I assume are those premises that are in Harrow. I would like to remind the committee of my representation when according to Harrow Council, they conducted an announced visit to a bar on 8th of December 2017 and found the same personnel currently managing the venue. One of the individuals was linked to another premises that had its license revoked in 2012 with the following decision. The panel believes that revocation of the premises license is appropriate and proportionate in circumstances to promote the license objective of preventing crime and disorder and public nuisance. There was another premises that the applicant associated itself with, which is Badsha Lounge, and is known as the Shisha establishment. According to my communication with Harrow Council, this premises has been associated with numerous issues over the years, including noise complaints, violence, allegations of strip shows, licensing breaches, drugs, and incidents of antisocial behaviour reported to the police and the council. Again, this is information provided by another council, which I would appreciate if the committee could take that into consideration. And it's linked to premises that the applicant made reference to, that she's been associated and worked. And she also made reference that some of these customers she knows from her previous work. As I stated in my representation and based on the evidence provided, the extended operational hours raised concerns about potential noise disturbance and antisocial behaviour. Based and plus the observations that we have carried out, based on the information I have submitted, we do not believe that residents will be adequately protected from noise nuisance and antisocial behaviour associated with this premises, and we strongly object to this application. Thank you.
Thank you, Mr. Cook. Ms. Anne Chapman, would you like to give your presentation, please?
Thank you, Chair. I'll pick up on a number of points that I put into my written representation. Firstly, the hours that have been applied for. This has been covered by Mr. Deere. The hours applied for are significantly in excess of the recommended core hours. And as has been said, these extended hours will lead inevitably to disturbance in the neighbourhood and to neighbouring residents, with people arriving and leaving the premises. That's not considering any noise from within the premises, but from people arriving and leaving. They are, as I say, in excess of the operational hours allowed under planning for the premises. And while as we've covered, it is up to the applicant to make a separate licensing hours application, I just find it, shall I say, I'll use the word disappointing, that she should consider that it is appropriate to disregard what has already been determined, and also the impact on local residents in applying for something as excessive as this. In terms of what's actually asked for, I noticed that there is no late night refreshment application. Late night refreshment, the availability of food when alcohol is being consumed does do something to mitigate the impact of people consuming large amounts of alcohol. And I would consider that for any venue that would otherwise effectively as a drinking club should be offering late night refreshment. Again, we can't enforce it, I appreciate that, but I think it's indicative of the applicants' perhaps lack of awareness of how to comply with the licensing objectives. And the closing hour, there is no half-hour wind down time from the end of alcohol sales to closing hour. We would normally expect any premises to cease alcohol sales half an hour before closing hour to allow people to finish their drinks, and hopefully not all patrons to leave at exactly the same moment. Again, considering the noise impact on local residents of this. Mr. Semper picked up earlier, he mentioned in response to a question about recent temporary event notices that the requirements of the license of any license that's granted and any conditions didn't apply to temporary events. While that may be the case, again, I find it very surprising that any applicant should not do their absolute utmost when awaiting to apply for a license to comply with what might be required under that license. They wouldn't surely, I mean, I find it very difficult to understand why someone would operate temporary events that clearly weren't in accordance with what would eventually be something they'd be asked to accept on a license. Again, just to me indicates a lack of understanding on behalf of the applicant. I think that's all I would say, just in summary, that I remain extremely concerned that, as was raised at the previous hearing, that the applicant really has not demonstrated an ability to comply successfully with the licensing objectives. And on this basis, I would ask that the panel refuse the licence. Thank you.
Thank you. Thank you, Ms. Chapman. Can I ask Mr. Robert Dyson, please, to give his presentation?
Thank you, Chair. Much has already been said. I will focus on this point of prevention of public nuisance, and particularly the noise element.
Yeah.
A couple of points to flag. Firstly, for my money, there's two key factual errors within that noise report. One is that there's a reference to walls being effective sound blockers. Of course, that ignores the fact that there are 3 flats stacked on top of the premises in question, and those 3 flats are not separated by masonry walls. They are in fact Edwardian, early 1900s lard and plaster ceilings and timber floors. I can speak personally to the fact that you can almost hear a TV on in flats abutting you in Leland Mansions. The suggestion that noise from essentially a nightclub would not work its way up the building is absurd in my view. Equally, in terms of the spatial element here, there are people putting their heads down probably 5 vertical meters from the club in question. That's the proximity that we're talking about. There's no meaningful space and there's no meaningful sound insulation. Equally, as other people have alluded to, that speaks to the issue of music and noise within the club. We've got potential issues of people either waiting in line or going outside to smoke. We know they will have to smoke outside, they will smoke in the alley. That's the bit that immediately abuts the entrance, and inevitably that will generate late night noise. And you've obviously got the comings and goings potential disturbances as well. The other factual error in the noise report, it alludes to the fact there's no windows on the eastern elevation of Leland Mansions. A cursory view on Google Street View will tell you that at the front of Leland Mansions there are 3 bay windows. All of them have a partial eastern elevation window. You can see that very clearly from the Broadway if you want to go on Street View, and therefore there are windows which, when opened, almost immediately abut the entrance below for the club in question. A few other points. I think it's been alluded to, there's this suggestion here in terms of whether belly dancing is or isn't erotic. I'd simply draw your attention to the fact that the vast majorities of people who've been visiting under these temporary event notices are young men, and you might want to draw conclusions from that in terms of whether or not there's erotic entertainment on show. If this were genuinely not erotic entertainment, you might anticipate a better spread of male and female attendees and members. For me, fundamentally, call this spade a spade. It's a completely unsuitable venue for a late night club, dancing and music club. It's an Edwardian building, so it's completely unsuited for prevention of noise escaping, but also it lies immediately in the vicinity of a whole array of residential flats. So myself as a resident and a number of other residents you've seen have objected. We will do so firmly on the basis that this will impact the day-to-day lives of residents.
Yeah.
On that front, I draw your attention also to the fact that there's potential Human Rights Act elements in play here. You'll all be very familiar with those. Article 18 particularly enshrining that right to privacy and family life in an unimpeded fashion, and I can't see how that wouldn't be infringed in a scenario where a late night music venue is operating 5 meters from people's beds. Thank you.
Thank you, Mr. Dyson. Mr. Semper and Ms. Bianca, do you have any questions to the responsible authorities and to the objectors, please?
No, in the interest of time, I'll deal with it all in summary, if that's okay.
Thank you, Mr. Semper. Fellow councillors, do you have any questions to ask the responsible authorities or the objectors? No. All right, I'll move now to confirming the conditions offered, which is only one, I believe. It's about the CCTV in the behind the bar by the storage area. Would this be?
Yes, and I was going to address you in summary about, because we're not insensible to what these good people are saying, and we'd like to make some further offers to allay their concerns, but I'd like to deal with that in summary, if that's okay. Once everyone else has summarised, I go last, I believe.
Yeah, Mr. Semper, no, I'd like to discuss the conditions now, please. If you have any conditions to offer, if you could just fire away.
Okay, smashing. Right. Okay. So, yes. As concerns noise, let's offer a noise limiter down there, please.
Okay.
And as concerns half an hour wind down time, I mean, I don't know what Bianca's position is on this, but if because at the end of the day, of course, it is your decision, Chair, with your panel. But if you want to have a 30 minutes, wind down time, no sales of alcohol in the last 30 minutes before the terminal hour, that is a matter for you. There was another one as well. There was another one. Stand by. You got me now. Yeah, that. No, I'll tell you what, I'll leave it there for the time being. There was, I'm sure at the back of my mind, there was a third one that is
Was
somewhere
it the
within my notes.
CCTV?
Yeah, yeah, absolutely,
Yes.
CCTV.
Yes.
Yeah,
Okay, so the
CCTV in that storage cupboard.
The bar
Yeah.
by the storage, yeah.
Yes, thank you. Thank
Okay.
you so much for that. Thank you.
Okay, thank you so much. I will move now to summing up. I will invite the police, please, to sum up. Sergeant, you're on mute.
Apologies, Chair. Right, so obviously I've given my concerns here. We appreciate the endeavours that Mr. Semper and Ms. Alenkei have gone through, and we still have concerns. Whilst we police appreciate that the applicant has undergone WAVE training and is a women's safety champion, it does not allay any fears that the police have with regards to safeguarding the dancers, as I have discussed in terms of the venue itself, with the toilet being a unisex toilet, also in terms of the contractual side of things, in terms of the agent be the artist, because as Councillor Nagpal has alluded to, the person who's given that statement of truth, I believe that company is dormant currently under Company House. So we do have a concern about the legitimacy of that particular company, or that in terms of how are we recruiting these dancers, which then leads into the hours going beyond the core hours, which not only would have an impact on the local residents, as Mr. Dyson has alluded to, in terms of the structural elements of the whole, the houses above, etc., it being an Edwardian premise, and the walls the structure of the walls are quite thin. So just in terms of that causing a potential public nuisance with the late hours, and also from a policing perspective, and whilst I'm not accusing Angels of this, but I just have a concern due to the fact that there is a high impact of antisocial behaviour regarding street drinkers, drug users. It could just have a further impact with this venue being opened that late at night, affecting the local residents who are above the venue, because there are flats above the venue. So from a policing perspective, I am concerned from a crime and disorder aspect, the violence against women and girls. And whilst I do appreciate the steps that Ms. Alenkei has taken, I still have concerns, because when I see, in terms of the structure, the unisex toilets, there isn't a specific place for these performers to get changed. It puts them in a vulnerable position. And also the fact that there isn't a delineated area within the venue, because it is quite small. So in essence, where are they going to sit when they're not dancing? And from the structural elements and the plan we've got, they would be interspersed with the clients, which again, potentially makes them vulnerable at that moment in time. So, Chair, from our side of things, in terms of what's discussed today, we do not necessarily support this application, as we do have concerns, and we think it might not be what it says on the tin. Thank you.
Thank you, Sergeant. I'll move now to Mr. Deere to sum up. Mr. Deere? It seems Mr. Deere is not with us. I will move then to Ms. Stuper for the moment. Ms. Stuper, can you please sum up?
Sure, thank you, Chair.
Thank you.
I'm not going to repeat what I said earlier, but as I stated in my representation earlier, and based on the evidence we have provided, the excessive operational hours raise concerns about noise disturbance and antisocial behaviour associated with the use of these premises. There are a lot of concerns, one of them being that the applicant is not taking any responsibility of the behaviour of the patrons as soon as they leave the premises or when they arrive. I appreciate that the applicant has contracted a sound engineer, but unfortunately that doesn't cover any of our concerns. It's a very vague report that doesn't really meet the threshold of a satisfactory noise report. And based on the information I have submitted, we don't believe that the residents would be adequately protected from noise nuisance and antisocial behaviour associated with the use of this premises, and we're asking the committee to refuse the application. Thank you.
Thank you, Ms. Meany. I will move now to Mr. Deer.
Thank you, Chair. Hopefully you can hear me now.
Yes, we can.
Lovely. Very quickly, I have nothing further to add. My recommendation is still to be refused. Thank you.
Thank you. Ms. Anne Chapman, can you sum up, please?
Also, I won't repeat what I said earlier, other than to say that I do not think that granting this application in any form will uphold the licensing objectives, and I would ask the panel to refuse it.
Thank you. Mr. Dyson, do you have anything to sum up?
Thank you. A few final words. While this property abuts the Uxbridge Road, it's fundamentally a residential area. There is a multitude of flats in the immediate vicinity of it. A noise limiter will only address the issue of music volume internally. It will not address the issue of comings, goings, smoking, cars outside, and the accompanying noise. As I said, people sleep a mere 5 metres from the venue in question. The noise report, as I've set out, has some obvious clear flaws, and in my opinion should be disregarded on that basis. I don't know how the individual visiting has failed to observe some of the most obvious elements. And finally, I can speak personally to the noise that I've heard emanating from the venue. So the suggestion that there isn't any is refutable by me and by my own ears. Noise has emanated. It is a disturbance. And at 1, 2 in the morning, of course, it keeps you awake. That impacts your wider life, your ability to go about and do your daily job, and impacts the family life of others in the vicinity as well. So I would implore you to consider how impacted the local residents would be, and therefore to refuse this application. Thank you.
Thank you, Mr. Dyson. Ms. Tupper, do you have anything to add?
Sorry, I just forgot to add something, if you don't mind. Thank you. I just wanted to, it's just a point for the panel with regards to noise and our noise service. I appreciate that we have a noise service, and if this application was to be granted, that the residents could use this, but I think it would be best to prevent getting to that point and protect the residents instead of having to put them through a long process, as we all know, of a license review and everything else. As I said, I do have serious concerns regarding this venue, and I think it would be fair on the residents for them to have to go through with all the issues and then be exposed to all this, and then for us to take enforcement action at a later stage. That's all I wanted to add. Thank you.
Thank you. Mr. Semper, can you please sum up? Mr. Semper?
Yes, ma'am. Yes, ma'am. Yes, indeed. Just get myself plugged back in. Okay. Right. I remember what I wanted to offer you. In the conditions we put that we'll only deal with bona fide, performance agencies and whatever. Can we change that bona fide, please, to reputable agent and with active company / partnership? Thanks. So that takes out the whole dormant thing. Okay. Right.
Sorry, Mr. Semper, I'd like to get a bit of clarification on this condition before we go to summing up. Can you please elaborate on this point? What do you mean by?
Yes. In section 18, we have a how many lines? 12 lines down. It says any entertainer performing at the premises must be employed via a bona fide events and entertainment agency. So I'd like to take out the words bona fide and import reputable and active company. If we can intersperse your Isabel, sorry, your lawyer will know how to phrase that.
Miss Allison, yeah, thank you.
Yeah, sorry, yes, I'm very sorry. Okay, so
Alison,
right.
Miss Allison, do you have anything to add on this one? Is it okay?
No, I think that's clear, Chair. Thank you.
Thank you. Okay, please go ahead, Mr. Semper.
Okay, right. Gonna go around the various representations, and then I'm going to sum up. Okay, right. So we've dealt with a reputable agent with an active company thing. Sergeant Kassar says that there will inevitably be street drinkers and drug users and people perpetrators of antisocial behaviour attracted to this premises. Well, with respect, no, they won't. They're not welcome, and we won't sell to them. He's discussed the balance of probability. Okay, yes, indeed, this decision is based on the balance of probability, but it's actually first, to get to the balance of probability, you need to actually talk about evidence. Okay, because this is an evidence-based decision-making process. So these objections are based on assumptions that these 31 customers who have an interest in Bollywood and belly dancing will arrive and abandon their motor vehicles anywhere, will make excessive noise whilst queuing outside. Once admitted, they cannot be trusted to keep their lecherous hands off the dancers and will engage in illicit acts, whether consensual or not. Will fight amongst themselves and overwhelm the staff of the SIA element. And then in leaving and dispersing from the venue will cause crime, disorder, ASB, excess noise and engage in sexual acts in public so as to affront the local residents and children. Okay, those are opinions based on fear and speculation, as I've alluded to before. There is absolutely no evidence of that whatsoever. The premises operated between April and May without issue, and I'm talking about recorded noise complaints. And the CCTV would have proved or disproved any of those allegations had they been made at the time. My understanding is that there were no complaints received whatsoever emanating from the operation of those premises at that time. We've taken no evidence of similar Bollywood or belly dancing establishments around the capital or borough. We take no evidence they are just a front for illegal acts or cause any such problems as alluded to, attract any such customers, invite or permit any such activities, or present similar crime, ASB or nuisance issues in their vicinity. Now, those are all facts. Okay, so that's all I have to say on that particular issue. As concerns Mr. Deere, he says that he concedes that the core hours are advisory, and they're advisory. You can step outside them if you have taken measures or can demonstrate that you are unlikely to undermine the licensing objectives. That whole operating schedule, as amended by yourselves today, does just that. He tells us that there will be queues. Well, I'm saying with these small numbers, they won't, because they're all pre-booked. He's saying that 1 to 35 is not enough. We're not actually, nowhere in the application to say there will only be one SIA element. What it says is that it'll be on a risk assessed basis. And what I'm suggesting is 1 is sufficient for 35. Okay, and because that is twice the ratio or whatever of what is the standard ratio of the SIA. Now, we've had a lot of criticism from Mimi about the noise report. She says that we didn't send it through in time. That's not entirely true, because I believe we did. Okay. On the 22nd of August, I was contacted by Matt Stewart of Ealing Council, who apologised profusely and asked my permission for this hearing to go ahead, because the pack had not been circulated and not been compiled and circulated, and therefore he thought it was to my detriment. That was the case. I said, look, well, we've been waiting for weeks, no problems on my behalf. And I sent to him again an earlier email containing all these documents that I'd sent to a David Hayter. Okay, and the fact that the pack wasn't circulated around the representatives and around the responsible authorities was actually nothing to do with me. But anyway, she says that I'm telling you to disregard the evidence. Well, I'm not necessarily telling you to disregard the evidence. I'm asking what evidence there actually is of confirmed noise nuisance complaints. And the fact that people don't actually know the existence of a noise nuisance team isn't a bar to people complaining. In my experience of 30 years policing, they usually phone the police first if there's a lot of noise and disturbance going on, and then that gets referred into the noise nuisance team. But look, it's pots and pans, but we're just knitting fog here. The fact of the matter is that place operated for a month and there were no neighbour complaints of nuisance, noise nuisance or statutory nuisance that I am aware of. Okay, she says that the security team, the security guy, the SIA guy could have approached the officers. Well, you can turn that on its head and saying these council officers could have approached the security team if they got concerns about the antics of people in that alley. Okay, we've heard evidence of things that have gone wrong at a venue in Harrow in 2017, and a licence was revoked in 2012, and a Batcher lounge with reference to previous noise complaints, strip shows, and ASB violence and drugs. This application is to be judged on its own merits. What happened in Harrow in 2017 and 2012? Frankly, they're irrelevant. Okay, now there's Ms. Chapman, lovely lady, mentions planning. She concedes that's actually irrelevant and will be dealt with. That decision not to give the extra hours is, I believe, subject of appeal by a guy called Martin Parrish, from a planning consultant from the planning group, and that will be dealt with by the planning authority. She complains there's no late night refreshment. Well, there is no late night refreshment because there's no kitchen. Okay, now we can't invent late night refreshment and put it on a licence. As a result, you know, there is no late night refreshment there, and we've conceded the half-an-hour wind down time if you, chair and panel, require it. I'm not sure it's necessary, but what happens in Ealing is what you say. So if you wanted, it's a matter for you. Just coming back to that Harrow thing, by the way, my understanding is that these problems occurred after Bianca left the premises. I think I'm just saying it's irrelevant, that's all. Okay, Mr. Dyson, he says that walls aren't affected noise blockers. Well, look, we've dealt with the expert evidence. You know, if people want to challenge the expert evidence, you challenge that with other experts, and I'd ask you to attach. And the fact that some people don't like its contents or think it's lacking in detail, that was the time to deal with it, and not just coming along here necessarily on the day with nothing to the contrary of an expert basis. I'd ask you to attach the appropriate weight to it that gentleman, his company and his qualifications afford. Okay, we've offered the noise limiter and as a condition. Right, so look, I'm just gonna wrap up here, okay, by saying this hearing is simply about whether this small but well-appointed establishment operating these hours in accordance with the operating schedule and the comprehensive raft of conditions as we've been sort of amending as we're going along will undermine or promote the licensing objectives. Very clearly, our position is it will not undermine them, and many of the issues raised by the responsible authorities and the neighbours are obviated by the substance, content and additional inbuilt safeguards present within the operating schedule. It's set against a set of assumptions. Okay, very briefly, assumptions. Here we go. Bollywood and belly dancing are sexualised forms of entertainment. 2, that clients attracted to these premises are predatory lectures. 3, that performers will be encouraged, obliged or coerced into providing sexual favours for money, or that the performers will be victims of sexual harassment and assaults. That Bianca will cause or permit such offences to be perpetrated on her premises, and that noise nuisance will undoubtedly emanate from the use of these premises as applied for, and that noise nuisance will arise from people queuing outside and leaving. Now, very briefly, Mimi says it's not, she's not happy with me saying that stuff going on down the road is nothing to do with our client. I just want to read you the actual section 182 guidance. It's not me saying it. This is handed down by the Secretary of State. This is government. Okay, and para 2.27 says, beyond the immediate area surrounding the premises, these are matters for the personal responsibility of individuals under the law. An individual who engages in antisocial behaviour is accountable in their own right. So I'll leave that as a matter of record. Now, as concerns all those 7 assumptions, right, we've provided answers to all that fear and speculation. There is simply no confirmed history or indelible evidence of noise nuisance, safety, ASB, drugs, crime, disorder, or sexual exploitation issues associated with the operation of these premises, or indeed any other cause for verified and evidence concern linked to these premises or this applicant before you. Okay, that's an undeniable and self-evident fact, and consequently I respectfully request that you do indeed grant this application for a premises licence as sought, supported by that comprehensive raft of effective conditions and any others that you, panel, chair and panel, deem appropriate and proportionate. So let us wish the Angels Club every ongoing success going forwards regarding this welcoming and niche establishment, which should prove to be nothing but a cultural asset to Ealing. Thank you very much indeed. Thank you.
Thank you, Mr. Semper. We will now move to the final part. The panel will retire to deliberate together with legal advisor and clerk. And I'm aware that the hearing has taken quite some time and that it's almost lunchtime. So we will reconvene back with our decision around 2:30. Alison, can you advise us on timing, please?
No, unfortunately, Chair, I've got another meeting at 2:30, and I believe Councillor Martin has a meeting at 2 o'clock. So
Yes.
I would say between 1:30 and 1:45. Obviously, if you haven't made a decision, we can let all the parties know, and we can come back. But yeah, I think we would like to be done and dusted by 2 o'clock if at all possible. Thanks.
Okay, so we will, let's say we will be back about 1:45. Is that okay?
That sounds.
Giving time for the clerk also to
and
draft the
if it
decision.
takes longer, then obviously we can decide what we're going to do. But yeah, let's set that as an initial time.
Perfect. Thank you.